Hi, this is Alan Gassman, and it's Monday, February 25th, 2013, 5 p.m., and I'm here with Jeff Howard of Ray Howard & Associates and Lester Perling of Broad & Cassel, and we're going to talk to you about Medicare and medical compliance disasters, what to do before and after the explosion. Jeff, welcome.
Thank you, Alan. I appreciate it.
And Lester, welcome.
Thank you, sir.
Let me just mention before we get started, on our website at Gassman Law Associates, or send us an email and we'll send you a link, is a 30-minute talk I gave on the Physician's Guide to 2013 tax laws and why you might want to spend less money if you're a physician, because the taxes have gone up, but there are some ways you can alleviate them to some extent. Also, Lester and I on the 19th gave a half-hour talk. It was actually Lester's talk on 4 hypotheticals and discussion of important medical structuring and regulatory issues. That's on our website, or we'll be glad to send you a link. And a couple of books Lester and I wrote, a couple more. But let's get to Jeff Howard. Jeff, we promised everybody that we would be done in 35 minutes, so we got 34 left. And where do we start?
You know, let's start with the first slide that's out there on Medicare registration. It's been such a hot topic lately. I've been in this business for over 27 years now, and I've had more issues with providers being deactivated from the system in the past 2 years than I did in the first 25 years.
Man.
And so it has a huge impact. And so let's look at the revalidation request. Most of the people out there probably have already received a revalidation request. If they haven't, they'll be receiving one soon. But you have to respond within 60 days. If you don't, your provider number is deactivated. Medicare is going more for the clinical labs and the IDTFs than they are physicians and physician groups. But nonetheless, you need to respond, and you need to make sure that everything is accurate.
What is a revalidation request, and how do you, if you don't know if you got one, how do you make sure you didn't get one?
You can actually go on to the PCOS, the Provider Enrollment Chain Enrollment System. I do not have the link right here with me, but you can log into the PCOS system, and that will allow you to see if you have a revalidation request pending, or if you have not done one, you'll know that you'll have one coming soon. But this is just Medicare updating their files. I was involved just last week. We got received notice from Medicare that a provider that had not updated his files from as far back as 1997, we were able to send the information in, get it updated and revalidated without any penalty, which technically that provider should have been deactivated. The original owner that was listed is now deceased. None of the other owners were listed. They had changed addresses or added additional addresses, which is an area that a lot of providers have not done when they should have done. I know Lester and I worked on a situation last year with a provider that didn't notify Medicare timely on the revalidation request, and they were deactivated, and Lester and I were able to get them reactivated. I had a situation, if you look at the detail, on the next page where it says report adverse legal actions. There's a provider who had a action against their license in the state of New York, and the final decision came out in July of 2011. They did not notify First Coast Service Options of this adverse action against the New York license because they were no longer practicing there. Medicare deactivated their provider number. We were able to get them reactivated in the system. But if you have any adverse legal actions, you need to make sure you change that as well. And Section 3 of the applications, address changes, anything like that with Medicare, you need to notify them within 60 days of when the change occurs.
Is there a list of things that you have to notify them of that we could distribute to everybody who's on this webinar?
Alan, we can put together a list.
Yeah, because it hadn't occurred to me that when I do something for a client, I should remind them that it requires notification.
Yeah, you know, and I say we can do a list. Basically, you do the 855B. Any information that changes on the Medicare 855B for a group, 855I for an individual, or an 855R for an individual reassigning to a group, if any sections in any of those change, that's what you have to notify Medicare.
Wow.
And so it can be quite challenging. You know, one of the things I'm not sure if we have more physicians or managerial staff on the line. Section 6 of the 855I has the managing control area, and Section 6 of the 855B also has that. I always discourage employees from being listed as having managing control of a practice, because then if that employee were to leave, of course the Medicare would need to be notified that that employee left the practice, number one. But if the employee stays or does leave, and the practice or physician gets themselves in trouble with Medicare, the Department of Justice, the Office of Inspector General, et cetera, then that person could be banned from working with the Medicare program in the future. Mm-hmm. So I always say that unless you're an owner of the practice, you really don't have managerial control. You may have management of day-to-day operations, but you don't have control of the practice. Lester, what's your thoughts on that?
Yeah, I think that's generally correct. You need to be cautious about who you put in that section. You know, in some organizations that are large enough, it may be you may be obligated to put an employee. And I've dealt with 2 revocations now where Medicare believed that individuals who should have been disclosed as managing employees were not disclosed, based on information that they received in a site visit. So you got to be careful if you don't want to use an employee, you've got to be careful about what authority you give them, because should Medicare, at least, you know, most of the time Medicare is going to take you at your word, but if there's a site visit, they may find information that makes them think that someone wasn't disclosed who should have been. So you're right, Jeff. All these areas are of concern these days, and I too, like you, in the last couple of years, it's been an amazing number of revocations as a result of failure to disclose or other types of enrollment issues that result in denials that would never have happened. You know,
I believe you and I believe you shared some information with me about a provider that changed billing services and didn't notify Medicare, and they got deactivated.
It could be literally be almost anything, and it's you know, their methodology now is deactivate now, ask questions later, as opposed to vice versa. So,
and then when they deactivate, they stop paying you?
They do.
They stop paying. The good news is, as soon as a provider is deactivated, they need to get outside help of some type, counsel, consultant, or someone that's knowledgeable in these areas, to help them file a corrective action plan to get back in. Sometimes, depending on the situation, Medicare will reactivate you to the date they receive the corrective action plan. Although you have 60 days to do it, you need to get it done tomorrow if you can.
And sometimes they will do it back to the deactivation date, depending upon what it is. But the thing that gets providers is it can cause significant cash flow issues, and Medicare has 60 days to review the corrective action plan, and they often take their full 60 days. So it can be a real cash flow headache, if nothing else.
However, I was involved and spoke with them today with Medicare. We filed a corrective action plan on February 14th, and we have an on-site inspection to verify the corrective action plan tomorrow, the 26th. So, you know, this is one that did move high priority.
Not good.
Yeah, not good. So, well, Alan, you want to move on to some medical documentation issues now?
Absolutely. Tell us some good news.
I haven't been shopping at Geico, so I haven't saved 15%. So. But the good news is we're making progress with Medicare, Medicaid, and many of the other carriers that are doing prepayment, post-payment audits on documentation. One of the things that's really come about in the past year is the American Medical Association published the guidelines for A&M coding in 1995. Then they came out with the new set of guidelines in 1997, and they looked at it and said, these are too onerous on the providers. We really can't expect them to abide by these guidelines. So what they've done is they've said you can code using the 95 guidelines or the 97 guidelines, and whichever ones you use, then we will audit you based on those guidelines. And the main difference is the 95 guidelines are the old traditional SOAP format, subjective, objective, assessment, and plan, which me being an old-timer, I like that better. The 97 guidelines were basically putting everything together for a electronic medical record where you go through and you check off, I checked, 8 out of 12 sections, therefore I meet the criteria to go to a level 4, possibly a level 5. If I only met 7 out of 12, then that could go no higher than a level 3. And so the new electronic medical records that a lot of people are on are more suitable for the 97 guidelines. But the clinician that still dictates their notes and lists out the detail of the visit normally does the 95. I was involved in an audit with Medicaid last year when the provider had used the 95 guidelines, very detailed, but he was not listing enough different areas of symptomatology, the review of systems, the physical exam, and this one particularly was a high-risk pregnancy provider. And so we're sitting there with Medicaid. Their expert was on the phone. All the attorneys were gathered around the table along with myself. My client was on the phone as well. And the expert for Medicaid kept saying you hadn't, reviewed enough areas. And so then I started asking the Medicaid expert, well, what guidelines do you use in the 95 or the 97? This physician expert did not even know what year guidelines they were using. So we were able to proceed through the remainder of the audit and end up doing much better because we called them on the bluff and made them use the correct guidelines. We said, we're using 95. You need to audit using 95. And the Medicaid Council agreed with that. So you just need to make sure that each provider knows what guidelines they're using and tries to adhere to them. Recommend that they print them out. You can, with Google nowadays, you can go online and just download anything. Just type in AMA E&M coding guidelines 95, and it'll give you probably a dozen references you can download them from. And so you look at that.
So what percentage of practices do you think are aware of this, and what percentage of practices do you think are unaware?
I would dare say probably 30 to 40% are aware of the difference in guidelines. I think if you were to ask 99 out of 100 physicians or providers, they probably would not have a clue as to which ones they're using. I think the practice coders are more aware of it than the actual providers are.
Wow.
And the providers don't necessarily have to have the in-depth knowledge that the coders do, but the coders need to give them feedback. When I do a chart audits, a lot of times I'll say the patient had the condition to warrant a level 4 visit. However, the documentation only supported a level 3 visit. And so a lot of times if you educate these physicians on, if you have a patient that comes in with active symptomatology, take a cardiac patient, for example, chest pains, dyspnea on exertion, dizziness, if you go through and ask them, does it resolve when you sit down? Is it only when you're, cutting grass or walking stairs? You list the who, what, where, when, and how. And if you address all of those areas and then have your review of systems and physical exam to support that strong chief complaint, then you can code the higher level. And both guidelines will give you, what you would need to do that, the 95 or the 97. And so it's education, and if the internal auditor does a audit and gives feedback on a regular basis, they should also have an annual audit on at least an annual basis from an external auditor. And then the findings need to go back to the providers, and there should be an education session with those providers at that time to show them. Because it's always easier to learn from an example than it is just to sit in a classroom and listen to an instructor.
Right.
So those are the things there. But, part of the other problem is people are, all of us human nature seem to be lazy and want to do as little as we can. People just click and bring data forward from the previous visit, and it may say that the patient has no pulmonary issues from the previous visit, but then they'll document something in the new visit that the patient's having some pulmonary issues. And so you see the records contradict when you bring them forward. Medicare said don't bring them forward. areas can be entered by the provider themselves, not by the assistant. And so we need to make sure that each note can stand on its own, but yet you can bring certain things forward, but you can't bring the whole note forward and then just add a footnote of today's visit. But you can also put in there, history unchanged, see visit of February 14th, and you can reference it back that way. And I know, Lester, you've been involved in quite a few audits and seen where providers didn't document the detail that they claim to have done when it comes down to the note versus the billing.
Yeah, that is definitely true. I think 2 points. One, it's interesting what you were saying about Medicaid, because Medicaid in Florida has never actually adopted the 95 or 97 guidelines, and it's questionable that Medicaid actually could enforce anything beyond what it says in the CPT manual, which is essentially nothing. That's just a interesting little legal note if someone needs it for challenging a Medicaid audit at some point in the future. In terms of the bringing old data forward, I mean, I've seen that come up now, and even in criminal and civil investigations by the federal government, where they start reading what they think to be the same note over and over again, and start thinking that there's fraud going on that they weren't even looking for previously. And when they read the note carefully, they would find that there are, in fact, some different items and that things have changed from one visit to the next. But it raises their antenna to a significant degree. So those kind of cloned or copied or pulled forward notes are just extremely risky for any number of reasons. They can also result if someone else is coding the services in coding a higher level than what was actually provided on that visit because of information that was brought forward that was actually repetitive or redundant with a prior visit and not actually performed on that visit. So it's, you just got to be really careful about using that type of technology in electronic medical record systems. I wish they would make them so you actually can't do it, but a lot of the companies market it with, look, isn't this great? You can copy things from one visit to the next, and that just poses a significant risk.
Yeah, and, one of the other things is some companies out there, a very popular one, I withhold name so that you don't have to represent me again tomorrow, please. But they set the defaults where it looks like the provider looked at all of these areas, and basically the provider has to pull back the default, or it makes the record look like it was actually everything reviewed on that default. And so you come out with a lovely 3 1/4 page document, and that's beautiful.
For a level 1 visit.
Oh, my gosh. For a level 1 or level 2 visit. And so you have to be careful there. And, you triggered another thought in my mind here when you're talking about the provider's coding versus the staff coding. I have much better results in an audit where the provider puts the level of care and does the coding of the procedure they're doing, surgical procedure, diagnostic, or whatever, than I do when we have the staff do it. I always say the provider should code it, the staff should verify it. And there's some situations, some billing services that do all the coding, and I just disagree with that. I think it's the provider's responsibility to code it. And so it's that way. But looking at what we have here for people to follow along, you look at the high volume procedures more likely to be audited. You need to make sure there's medical necessity. Those are the areas everything needs to be documented, but these areas will be audited. So you try to make sure there's concise documentation, follow the local carrier determinations or national carrier determination to ensure that you have the medical necessity documented in the chart. And I always tell providers, make sure medical necessity is documented, but if there's not really medical necessity there, don't doctor the chart, and or else they will get themselves in trouble. High volume billers also have a target on their back. I was involved with a pathologist not in the state of Florida, but a different state, that was the highest volume biller for 88305 in the state, and that was because the doctor had an associate leave, and while they were getting someone new in, this doctor spent 6 months doing the work of 2 pathologists, and so he would work long, extensive hours, and they actually looked at him, and end up doing okay in the audit, but nonetheless it was a hassle. I know of a situation here in the state of Florida where there's a provider that got documented, got audited because he had documented more than 24 hours worth of services a day on a continuous basis. But this physician was a hospitalist that spent a lot of time in the critical care and pulmonary area, and it was spending an average of 37 to 38 minutes with each patient, which, according to the Medicare guidelines and the CPT guidelines, that's 1 hour of critical care. But every 2 hours, they were able to bill the equivalent of 3 hours. And so this physician got targeted because of that. And so I always tell people, try to get a hold of your comparative billing report from First Coast Service Options. When you get it, analyze it, look at it, get some advice on it. I know for cardiology, Medicare sent out a lot of those comparative billing reports at the end of the year so that they could see where they compared to other cardiologists. And since Florida is one of the highest utilizers of cardiology services and diagnostic services, they're always looking at it. And I know there's been so much talk about these RAC audits and all that's going on with them. But when you look at it, every dollar they spend yields $7.90 worth of return money.
Wow.
And they collected over $4.2 billion last year. Payments, and that's billion, Alan. You know, those areas, they're not going to back off. And Secretary Sebelius last week was crying about the sequestration and trying to stop that. You know, she wasn't saying my physicians won't be able to provide services to Medicare patients anymore and may have to lay off staff. She was saying, if you cut us 2%, that's going to cut a way that we go after all this fraud and abuse. And so while it sounded good on the surface, she's part of that Washington-Baltimore inner circle and doesn't really realize what goes on for those of us out on the outside.
She'll be sending Morgan & Morgan after it.
John
just like they did with the tobacco case.
Mm-hmm.
Well, Jeff, when you walk into a medical practice and there's 4 doctors, you know, of the 4, how do you stereotype where they are as far as compliance is concerned? Is there always one that's, you know, a mess and one that's always real clean and a couple in the middle, or what's going on in the field when you walk into a practice that's gotten an audit?
Alan, you summarized it well. You always have your bad boy. You always have the one
or
that
bad
goes
girl,
to,
right?
Or bad girl. You always have the one that goes to Sunday school every week and lives the life accordingly. And then you have a couple in the middle that just want to work and do their job and treat patients and go home and enjoy their family. And so you usually can surmise who the outlier is. They don't get the dictation done timely. They seem to have conflict with the staff. You know, I have some that just say, I'm going to code a 99213 for every established patient office visit because I don't want to be looked at by Medicare. Well, they're going to be looked at by Medicare because of utilization on the comparative billing. And Medicare is looking at this data with or without you looking at it. So don't be afraid to request it, that it'll trigger something. They already know it's out there, and they're just waiting for you to get too far apparent before they say anything. But yeah, the diversity in groups is always a challenge. You usually have the one physician that's the managing partner, so to speak. May not necessarily be the senior partner. It may be someone that just has an interest in management. About 10, 15 years ago, I saw more physicians going back and getting MBAs than administrators were.
Right.
Because they wanted to be on the ball game, and these are the ones that had the foresight to say, we're going to have to be businessmen and women to survive in the upcoming environment. So usually we can sit down with the outlier provider, and then we can help them see, this is what you need to be doing. Here's the reason why, and here's why we need you to get on the ball game.
Is it typically the older physicians or the younger? I would think the older ones probably have less compliance nowadays.
Well, they don't want to use the electronic medical records, and they still want to do the old dictation, and they say, I don't have time to see patients and play with computers. And so from a documentation standpoint, those are the ones that we see problems with. Then you have I'd say it's probably not discriminatory. You have the new one coming in that wants to do things right but doesn't know how to do things right, or they just say, I learned everything in school and I know what to do, don't mess with me. Then you get the established provider that's been there, has a thriving practice, can't see enough patients in the day just because the patients line up. And that one becomes non-compliant because his desk looks as bad as my desk looks right now from just lack of time to get things done. I have a cardiologist in Florida that I left his office at 9:38 one night, and there was still one patient in the waiting room.
Wow.
And the last scheduled appointment was at 6 o'clock. And people would just wait and wait. Now, we ended up having to do some work with this provider. Lester can comment on this. This guy was going out and buying pizzas and having all kinds of excessive stacks in the room for these patients that are willing to stay late because the provider wanted to make sure they were all seen. Of course, I wish I could go to a cardiologist that ordered pizza and soda for me to sit there and eat too. I usually get the other lecture.
Well, why are you eating the pizza?
Yeah, that's right.
Yeah, I don't know. I don't think the feds would necessarily pursue him having pizza sitting around his waiting room because he's keeping people waiting for too long. I think that his malpractice carrier, from a risk management perspective, would be more concerned because he's probably got a lot of angry patients. Yep. Who get annoyed sitting around like I would. But I would get up and I give a doctor 30 minutes and I'm history with that doctor. But other people are willing to do that. But yep. But it does create, I think, a risk management issue for the doctor because you do create some ill will with your patients.
Yeah, I agree. I definitely agree.
All right, we got about 7 minutes left here, so should we go to audits? Or you want to skip?
You know, the main thing is they just need to make sure that they pay attention and on all the documentation. Any documentation that's sent out, don't let the clerical level be the finalized review it. Make sure that it's someone that's accountable, that's knowledgeable, that realizes this is, you know, what needs to be sent. Anytime that I gather data for an audit, if Medicare, you know, were to say we want to see everything from January through June of 2012, then I would go through, and they'd list the patients, I would go through and list the full billing data for that time frame for that patient. And then I would go through and make sure that any lab test, any diagnostic test, that there's a copy of the daily visit for everything that gets sent out. One of the biggest things we see is people respond to audits and don't put the complete data in there. And then Medicare comes through and says, we want money back. They say, but I have it right here. You know, when they get to looking for it, but Medicare says we'll go to the appeal process, and in the meantime, write me a check for $100,000. And so make sure that you're tracking what's being sent out. And a lot of times we'll do what we call an overview for clarification purposes only. I'll sit down with the physician, and we'll go through the charts, and we'll make a walk. Basically, it's a written narrative of what's going on with the patient. You know, I saw this patient for, you know, a history of X, Y, and Z. We've tried this, it didn't work. We tried that, it didn't work. We've gone this way, and we're starting to see some response to the treatment therapies. And so we walk the auditor through it, and then they can just flip through page by page and see what's there. And we've had good results with that. And usually the physicians get a little not as detailed as an outsider does when they do that. The physicians say, well, it's all right there. We don't need to do anything more. But usually there's a little bit more that we can document that'll help tie the visits together and the reasons for the test. And so I would like to see them do more of that type stuff. Lester?
Yeah, I think that's a good point. I think, you know, in an audit of inpatient hospital visits, oftentimes the physician will get the note for the visit but won't get the orders and other documents that reflect what occurred during the visit, what, you know, how much work he did. It may not be as well, it may not be all in the notes, it may be in the orders and other places in the records. So that's, you know, thinking about what needs to go to Medicare for an audit is a great idea, and trying to make it easy for the auditor without committing fraud or falsifying the record, but giving the auditor a path to follow is helpful because they don't have a lot of time for each record. So the more quickly they can see the information they're looking for, particularly what's tied to an LCD or a local coverage determination, if there is one, the better chance you have of getting that visit approved for payment. So.
Yeah, and if you could go ahead and comment on, people still don't fully understand what it takes to correct a medical record. They say, oh, I can't do it, and where, you can go ahead and explain to them they can, but the other thing is on electronic medical records, they need to make sure that they're doing official entry. So if you can share a little bit on that with them.
Yeah, that's a big point. It's coincidental. I was talking to an administrator of a 50-physician practice today who has a physician who is very bad about getting his documentation in, and then he'll go in an electronic record after the fact and amend it, not changing the date, and that's going to one day be a real problem. Anytime you do a physician or practitioner, they can do late entries, but it needs to be marked as a late entry or an amendment, and it needs to be contemporaneously dated with the date that it's done, whether we're talking electronic or handwritten. But also keep in mind that those types of entries lack credibility, particularly 6 months after an office visit, the doctor goes back and does a late entry. It's, oh yeah, I forgot to say I did a complete social history. No one's going to believe that, and worse than no one believing it, it could look like an attempt to manipulate an audit or otherwise be a cynical maneuver. So you have to be very careful with late entries, but if you're going to do them, then they clearly need to be marked as late entries and dated contemporaneously with the date that they're done. But people need to keep in mind that they do lack a certain amount of credibility, and before doing them, you really need to think about what you're doing and why you're doing them.
I agree. I absolutely agree. And Alan, how are we doing on time?
I'm sorry, we have 2 full minutes.
Okay. One of the things
longer. Go ahead.
Okay. One of the things I wanted to just touch on is HIPAA violations. I believe it was January 25th, the new guidelines on HIPAA came out, and so we're seeing more and more HIPAA breaches out there by providers. And so you need to make sure that you have the high-tech business associate agreement in place. You need to make sure you have the protocol for notifying the patients, notifying any appropriate agency, what you're doing to prevent future breaches. We had a situation where a billing employee for a billing service billed for a hospital-based pathologist in that particular town. One of the policemen was shot in a shoot-'em-up on New Year's Eve, and they heard about it on the news. So at 9 o'clock at night, this employee used her login to go into the hospital system to do an unauthorized access just to read the PHI on this particular officer. And so the hospital notified the billing service, notified the provider, then the billing service, and the employee has been admonished, was on leave without pay until the whole thing was resolved. Turns out the hospital attorneys did determine that it wasn't a true HIPAA breach because this person had a access code to get in there. However, the person did not utilize the minimum necessary rules, and HIPAA, where you see the least data that you need to do your job. So there was an issue there, but it all worked out. But just make sure that you have everything in line with HIPAA would be what I would say would be a key area for providers.
And Lester, what were you saying about some new rules in this regard?
Well, there were some new, as Jeff mentioned, in January 24th, 5th, I forget. The Office of Civil Rights issued some final rules under high tech that further, I hesitate to use the word clarify, but in their mind clarify some of the requirements under the High Tech Act. So, HIPAA is still very much of a living and breathing statute and set of regulations that, as Jeff mentioned, providers really need to stay on top of. And we're seeing probably a tenfold increase in investigations being initiated by OCR in the last just few months. It's incredible how much more enforcement there is coming. That's just getting underway, and it's just going to get worse. I mean, it's been I've talked to other attorneys who have experienced the same volume of increased enforcement activity, and they're just ramping up incredibly. So
oh my
providers
gosh.
really need to take this seriously.
Okay. Well, I think that's a good note to end this on. It's really getting worse and worse as far as the compliance is concerned, but those people who are extra careful are going to be a lot safer than the rest. Well, we welcome questions. We're out of time, and I don't really want to keep anybody late. Everybody who signed on is still on with us. Thank you very, very much. You've got email addresses here, and I'll leave this on the screen. And please feel free to send any questions to me, Jeff, or Lester, and to also give us suggestions for future talks, or maybe Jeff and Lester could just sing sometime.
But great singer.
Excellent.
Yeah, you wouldn't have many people left on that one.
And even my mother said I have a face for radio.